and I'm going to start with a slide, so bear with me while I share my screen. So, good afternoon, and let's get started. We've had cases about snails and carbolic smoke balls, and now the dreaded Japanese knotweed. It's funny how big cases can be about odd things. Our webinar today is about the effect this Churchill case will have on PI and ClinNeg claims, rather than the facts and the outcome of the knotweed case, although we shall briefly review the chief aspects of this. For any conspiracy theorists, could Churchill be part of something bigger? Well, I'm going to suggest that it is, and I'll get onto that in just a moment. First, however, I would like to introduce today's panelists. I'm delighted to welcome my fellow directors at Trust Mediation, Francis McCarthy and Brian Dawson, both very senior and experienced mediators. I also hope to introduce very shortly, and I know he's very busy today, but he's expecting to join us, Dominic Nolan, KC of Hailsham Chambers. Dominic has prepared a very helpful note on the Churchill case, which summarises it and raises some observations of his own, and that has been circulated to everyone. I hope that you will find that of interest, and certainly I found it a very lucid explanation of the judgment and the key features. Dealing with the logistics of the webinar today, the central part of the webinar is a discussion between the audience and our panel. And if you will, please use the Q&A tab to put your questions and observations to us. I will be keeping an eye on that, and I will bring up those questions and observations at an appropriate time during the discussion. Towards the end of the webinar, we will ask for your views by some poll questions, and in the usual way display the answers to those. So we said, as well as dealing with Churchill, we would be doing a roundup of developments in ADR for the year. And I want to move on to the thought that Churchill is in fact part of something rather bigger. So let's have a look at some recent developments of civil justice policy. We now have small claims mediation that has been introduced as part of the idea to integrate mediation into the civil justice system. That is underway, but if you look at the MOJ policy papers that have been published, it's quite clear that it's intended that this shall be extended to both fast and multi-track claims. Dominic, welcome. Very good to see you.
I'm sorry, I'm joining late.
We know that you were very busy today, and we've explained that you've been delayed a few seconds. But delighted you're here to join us. I'm just looking at the civil justice policy developments. I dealt with the small claims mediation. The Civil Justice Council pre-action protocol report is worth a read. And that includes a recommendation, which at the moment is merely a recommendation, that the pre-action protocols should include an obligation to engage in pre-action dispute resolution. Last, and certainly I believe by no means least, is the inauguration of Sir Geoffrey Voss's online procedural rules committee, which now has statutory basis. And this is the engine room, I think, of the Voss vision of developing an integrated online civil justice system, of which ADR will be a component. And the quote there you will see speaks for itself. And in particular, Sir Geoffrey takes the view that ADR is part of the process. It's going to be part of the rules, and not something which, as in the past, to some extent has been optional. So let's have a look at Churchill. I remind you again of the note which Dominic Nolan has very helpfully provided. You will find, if you've not seen that, you certainly have an email giving you details of how to access that. So let's get into Churchill, and I'm going to start off by putting a question to Francis McCarthy. Francis, what is the main finding of the Court of Appeal in this case? You're on mute, Francis.
This is the curse of the modern era, isn't it? It doesn't matter how often you do it, there's always some fool who's on mute. Yes, the main fuss of Churchill, and the reason why we're all obsessing about it, is because it's overturned Halsey. And to remind everybody, in Halsey, it was a Court of Appeal decision, and they were considering whether they should apply cost sanctions on the parties who won in the cases that they were looking at, on the grounds they'd refused to participate in ADR. And in that case, they held that they wouldn't apply a cost sanction, but a number of factors were identified as being relevant in deciding whether the refusal to mediate was unreasonable. And in that context, Lord Dyson made a number of comments on the question of whether the court had the power to order parties to mediate against their will. And we have all, I think, taken that as meaning you can't compel people to mediate. But in the case of Churchill, the Court of Appeal looked at this and decided that these comments of Lord Dyson were not a necessary step in reaching the court's conclusions. And that's because the issue of whether the court can order compulsory mediation didn't arise in Halsey and didn't fall to be decided in it. And therefore, Churchill said, well, they're obiter then, and are not binding on the court. And so the court, therefore, in Churchill, felt itself free to decide afresh whether the court had power to order ADR. They considered all the case law. They considered in particular the European Convention on Human Rights, and I'm sure we'll talk about this as we go through the webinar. And they decided the court does have the power to order ADR, provided it doesn't impair what they called the very essence of the claimant's right to proceed to a judicial hearing. That's Article 6 of the ECHR. And it was made in pursuit of the legitimate aim of settling the case fairly quickly and cost effectively. And it was proportionate in achieving that aim. So in practice, I think we've all been considering, and you'll see this as we go through the webinar, that courts have been making orders, in effect forcing parties into mediation. But Churchill now is the rubber stamp that that is their right and they can do that. But there's a lot to be discussed about how it will work in practice.
Francis, thank you for that. Just a moment on logistics again, just to remind you, this is being recorded, and also we very much encourage your questions and observations using the Q&A tab. Brian, I want to turn to you next, as well as your roles as mediator and arbitrator. I know you sit as a deputy district judge, and I'm interested in judicial discretion. The courts now have this power following this Churchill decision. How do you think that the court will look at exercising discretion when considering whether or not to order ADR?
Thank you. First thing to bear in mind, of course, is as a DDJ, I'm right at the bottom of the judicial food chain, so comments should be in that light. But I do at least, I suppose, understand discretion. I think the first thing to do is look at how courts are doing it already. If I refer to, for example, a case of Mills and Reeve, Trust Corporation and Martin, which is a 2023 case, there the judge, J. Kelly, asked himself two questions. Firstly, do I have the power to order the parties to mediate? And secondly, should I do so, or stay matters so that they can do it? Now, the first of those questions, as you know from the case, and as Francis has just pointed out, we already know the answer to now, which is yes, you do have the power. Principally because in Article, if a party's right to go to a trial in the end, if they want to, is not fettered, then you have the power, and you have the power also in your management powers as a judge. So in future, we'll just be looking at the second. Now, in that case, His Honour Judge Kelly decided that for reasons which are entirely case specific, and I won't bore you with, that he shouldn't order those parties to mediate or stay so that they could. And so going forward, we therefore just have to look at, well, exercise of discretion. Exercise of discretion is always in accordance with the overriding objective, but are there any guidelines? Answer no. Churchill, Sir Geoffrey Voss in Churchill did not outline any guidelines as such. However, what they did say was that the the issues raised by the Bar Council, and indeed the issues outlined in Halsey by way of guidelines, still remained relevant. And if you remember, those were the nature of the case, the merits of the case, whether there had been any delay, whether anyone had tried mediation before, and most importantly, proportionality. Going forward, I think, bearing in mind comments made in Churchill, it's likely the merits of the case will be treated with a certain amount of suspicion. These were comments that have been made over and over again in past case law, but now I think they're losing their emphasis. And certainly as a mediator as well as a DDJ, I've always felt that when one party doesn't think the other party has a case, that's probably a very good time to talk to them or to try and resolve matters, because you might actually find out that they do have a case. So I think the merits argument goes, but other than that, the factors identified in Halsey, the factors identified by the Bar Council will be taken into account, but plus, Sir Geoffrey Voss says, other relevant factors which you must take into account. Most importantly, as Francis has already observed, would mediation impact on the very essence of the party's right to go to a judicial hearing? Secondly, is it in furtherance of a legitimate aim to resolve matters at reasonable costs? And finally, and most importantly, I think, is it proportionate? So I think that is the basis on which the court will approach their discretion going forward.
Well, thanks very much indeed for that. You mentioned a case, and I know other cases are going to be referred to. We will send an email around with the various cases and references, rather than try and give them here. Now, Dominic, if I can turn to you, I'd like to ask for your observations on this case, but with particular reference to personal injury and clinical negligence claims, please.
Yeah, thanks, Tim. Well, for those of you who've had the opportunity to read the note which I prepared and published last week and the week after the decision, you'll know that really my overall view of the decision in Churchill was twofold. First of all, it really came as no surprise given the context and given that the case had been reserved to Geoffrey Voss as Master of the Rolls, with his known commitment to driving reform of the system. But secondly, that it was a disappointment to see that the judgment didn't go any further to give the parties some idea of how and in what circumstances this newly confirmed power to push parties towards ADR is going to be exercised. And it's very interesting to hear Brian's input, as it were, from the sharp end, as somebody who sits and hears cases, as to how that is likely to be considered. But I think the litigants and those who do a lot of litigating would have welcomed some more guidance. A footnote straight away. I still, Sir Geoffrey wants to call it non-court-based resolution or some different term to ADR. My own personal view is that ADR will stick this. If I hold this book was written 10 years ago, which many of you will recognise. And I think with ADR being so well sewn into the practice directions and so on, that the term will probably stick. I think it's best seen as alternative to trial, not alternative to mainstream, but just alternative to trial. But putting that footnote to one side, I think front and centre the implication is that it is going to give an impetus to the need for parties to demonstrate to the court that they have considered resolving their dispute in a way other than at a trial. Framework's already there. Any practitioner in the field will know that the standard direction for multi-track personal injury has as paragraph 2, as a standard direction in every case, at all stages, parties must consider settling this litigation. And any party not engaging in a means proposed to settle it must serve a witness statement within 21 days. That's personal injury. And again, I won't go at length because many will be familiar. In clinical negligence cases, every clinical negligence directions as a standard paragraph 2, alternative dispute resolution, must consider settling, the parties must consider settling the litigation. It's very specific in clinical negligence claims by any means of alternative dispute resolution, including, it says, roundtable conference, early neutral evaluation, mediation, and arbitration. And again, a requirement for any party declining an offer to serve a statement as to why. So that framework's already there for the court. And I think what we may see is from on high, a directive given by the Master of the Rolls as head of civil justice, that the Court of Appeal, having ruled on this question, the court is now expected to pick up the baton, as it were, and the courts will be expected to be more pressing when asking questions of parties at directions hearings, what proposals there are for a resolution on an ADR basis. And there's more coming because, of course, as Tim's already referred to, the Civil Justice Council Working Group on a general, that is across the board, pre-action protocol reported in August 2023 that a proposed direction that there's a requirement of the court with sanctions, sort of Denton sanctions, one would assume, before proceedings are started. Now, again, how that will be implemented, one doesn't know that, but it's not on the statute book yet, but that's a proposal. So bringing all these things together, certainly in personal injury and clinical negligence, I would expect there to be a much greater impetus for the parties to demonstrate that they've tried their method of ADR. The response, I would say briefly, would be, and I know many parties, sophisticated parties, and their experienced solicitors are working in this direction anyway, but I think anybody active on either side, claimant or defendant, will have to start to have a strategy in place. As it were, the default is, in every case, is, well, what's our ADR before we think about proceedings? Now, again, I suspect many already have this, but I think the need to have that strategy in place, to be on the front foot, as it were, is going to be very important. One other footnote is I was surprised that the case of Churchill itself was chosen as the test case. Obviously, the court has to wait for the right case to come along, but I'm surprised the court did not say more about the in-house scheme that it was proposed Mr. Churchill's claim should go into. When I say in-house, I mean in-house to his opponents in litigation. I won't list the things that were wrong with that or said to be wrong with that, but what I am saying is that I think one party's in-house, as it were, claims assessment is unlikely to be a form of ADR that finds favour with the court, unless it is a very low value and anything else would be disproportionate sort of case. I think you really need to be thinking about a settlement meeting on equal footing, or some independent assessment, like a neutral evaluation or mediation or whatever. So I think the single word, a single sentence I would use to sum up the effect is, I think the impetus towards ADR is going to be very strong and is going to grow. And those who litigate ought to be ready for that and have their procedures in place. Those who know the Master of the Rolls will tell you that when he puts his mind to something, it has to get done. So these are not sort of airy threats of reform. You can be sure that reform is coming.
Dominic, thank you very much for that. And members of the audience, do encourage your questions and observations. We have one which I'm going to put to you in just a moment. But then the panel, and I'm going to put these questions to you as well, we're going to consider 5 questions. How is this case going to impact on pre-litigation behaviour? How is case management going to change? How will ADR fit in your toolbox along with Part 36, JSMs and trial? And what impact do claimant lawyers think this case will have on defendant lawyers and vice versa? So those are the questions we're going to run through. And we're going to start with the one which has already been put up, and that is about the voluntary nature of mediation. The questioner says, and by the way, you can put in your questions anonymously, as this questioner has. I understood mediation to be a voluntary process. How will ordering, compelling parties to mediate impact the process and outcomes? So, panel, who would like to kick off with that one?
Well, shall I kick off, Tim? I think that I think this is a really, really important question, because I think it's a single thing, in my view, of Halsey that Dyson was hanging his hat on when he was talking about the difficulty of compelling people to do mediation. That that people would not be enthusiastic about it, would just be blocked, and so on. And I think that there remains a great element of truth about that. And I think as mediators, we have seen people coming along to a mediation with it appears to be an avowed intention of not engaging and not cooperating. But what I also would say is that what has been surprising to me as a mediator is how frequently people turn up with a clear intention of not engaging properly, but actually ending up by engaging and settling the claim, or at the very least, engaging to the extent that they resolve some important issues of the case. And with a good or skillful mediator, who encourages them to listen, actually listening to the other side and recognizing that there must be something in this claim and understanding a bit more about it. So I do think that there will always be a percentage of cases where one party has been dragged to the mediation and will not engage at all. But I suspect this will be much, much smaller than you obviously anticipate, questioner, from the tone of your question. And I would just say that the downside of it, however, from my perspective, is that I think this is going to lead to a massive amount of satellite litigation about if a party is not engaging properly, does that mean that they are in effective breach of an order to mediate? And I think we'll see a huge amount of litigation about that, which will make the position quite uncertain for some time to come. And I think that's sadly something that perhaps the court could have given some guidance on in Churchill.
Dominic.
Yeah, I just to echo what Francis said, there's many a case where one goes thinking, well, this is never going to settle, and yet there's some common ground that's achieved, and sometimes quite a lot. I think the existence of the court's power and the potential for it to be used is probably going to have more influence than the court actually ordering parties to go to mediation, in the sense of you have a dispute even where the merits are tilted very much in one side's favour. There's actually a reason for nobody to be embarrassed to say, well, we're going to have a meeting. You're not giving anything away to say, well, let's have an ADR meeting, even when you think you're strong, because you say, well, we have to have some sort of meeting. The court expects it, so let's have our meeting. So in that sense, it might make people go, because it becomes, as it were, routine. People who would otherwise be reluctant to go into some form of ADR might say, well, we've got to anyway. And then lo and behold, things go better. So it may be that just the existence of the court's power makes a difference rather than its exercise. But as for what the Civil Justice Council called perfunctory performance, Francis's reference to people who turn up for their arms and say nothing all day, yes, the potential for satellite litigation is vast, but bear in mind that a recent case of Jones and Tracy reinforced the point that a letter saying, I invite you to a mediation, doesn't attract privilege. It's whether you write without prejudice or not. Just saying, what about a mediation? That's not a privileged letter. But everything in the mediation is privileged. And where do you start when you get to a costs hearing? When you won, there was a mediation where they said nothing and did nothing. It's all privileged. I don't know. You can say that's not compliance with the court's order. And I don't, as Francis says, I don't think the Court of Appeal have thought this through and have addressed what the consequences are with sanctions if people only pay lip service to the court's order.
Thank you, Dominic. Brian, anything to add to that?
Yeah, just a couple of things. It's an entirely appropriate question. There is always, I agree with everything that the last two speakers have said. There's always the point if you lead a horse to water, it might actually find it's thirstier than it thought it was. But I think the two factors are, as Dominic said, the fact that the judges can or could order this doesn't mean they're going to, and I suppose it rather depends on the nature of the case, and it's the factors hopefully identified by the judge that would make this an appropriate case for mediation in the first place, even if people were compelled. And that leads on to my second point, which is it rather depends on why somebody's reluctant to go to mediation. There can be very good reasons for not wanting to go to mediation. There can also be, dare I say it, some misunderstanding as to what the process involves, and somebody might actually be quite surprised. My experience is the same as Francis's, which is where I've had cases where one party's not wanted to attend. frequently, once they're there, they do engage. And I've never really bought into this idea that mediation is pointless if one party is reluctant or doesn't want to do it.
Thank you, Brian. I would just add of my own experience that there are similar arrangements to what we now have in many other jurisdictions. Australia, for example, the courts regularly instruct parties to go to mediation and have done for a long time. Toronto is another example. And there was also a study carried out in Toronto which looked at the different attitudes of lawyers, and where lawyers didn't want to go to mediation, the outcomes were not as good as the lawyers who were in favour of the process. So I think that is interesting, but most studies carried out have shown there is very little difference in the outcome so far as whether the mediation was voluntary or whether it was court ordered. So I think there's some comfort to be taken from that. In terms of the process itself, I think mediators will need to be aware that the court may have ordered mediation, and they will need to be thinking about how to deal with that. And I think our skills and training are certainly up to that. The final point about satellite litigation, I think, is very interesting. I think you need to be careful what you wish for, because I think if anecdotally it becomes clear that there are parties who are simply folding their arms and saying, well, I'm here, but I'm not going to say anything, that will lead, I believe, Sir Geoffrey Voss and those who have got these reforms in mind to consider the privilege which does attach to the mediation itself. And at the moment, everyone enjoys the cloak of confidentiality. Is that going to continue? I just raised that as a question. Certainly, Lord Wolfe, I think, was of the view at the time of his reforms that the court could inquire what had happened at the mediation in terms of conduct and costs. So that, I think, is an interesting area to look at. But meanwhile, we have some further questions, and let me deal with the next one, which comes back to case management, really. But question from is this: in practice, will we really see DJs or masters actively encouraging ADR at, for example, CCMCs? It does not happen at present. So I think the underlying thought there is the impact of this decision and the direction of travel of the Courts of Appeal and these policies. Is that going to have an impact on how judges deal with case management? Brian, you've already expressed a view on this, but to answer that question in terms, do you think that you're going to see more active encouragement?
I think it depends. It depends, as Dominic said, on guidance from above. We people at the bottom of the food chain, we are guided by the higher authority than us. So it depends on direction of travel. It depends on we know that Sir Geoffrey Voss is very keen on it. It'll depend on the training that judges received. It'll also, I suppose, depend on individual courts. So to say it doesn't happen, I mean, as we know, let's deal with the 2 points. Can it happen and does it happen? Firstly, we know, as Churchill dealt with, that under CPR 1.4, the parties got to engage with ADR, and our case management powers give us the power to, 3.1 is that we should manage the case in such a way as to enforce the overriding objective. Also, we have that wonderful 3.1.2.m or whatever it is that says a court can take any action it feels fit in order to further the overriding objective, and we have power to stay. So it's there, and actually it has been used before. If we look at the case of Hadley and Presbolo, which is the 2023 case, where Master Victoria MacLeod ordered the parties who were in dispute about a complex personal injury cost budget. This was a budget of over £1 million and was a very complicated one, and she ordered ADR. So it is happening actually, but rarely. In that particular case, the ADR was ordered, was actually very successful. There was only one item outstanding at the end, which was that the defendant's budget was agreed, the claimant's budget was agreed, apart from the claimant's attendance at multidisciplinary team meetings. That's the solicitor's attendance at every meeting. And that was the sole matter really, which came back to her at the end. And again, I won't bore you, but she decided, well, she didn't think that was reasonable and proportionate. And in any event, she didn't think the costs were reasonable. So it has been done before, and it'll rather depend on what the judges are told to do. The big issue, which I think Dominic touched upon, is the issue of sanction, because it seems to me that if this has teeth, if sanctions are imposed, and we know that the court does have power to impose sanction, but up until now they've been quite reluctant to use it for breach of protocol, for failure to engage. But if this is pushed by Sir Geoffrey Voss and others, and sanctions are imposed, let's leave aside for the moment how easily they'll be done. But if sanctions are imposed, then I think it will lead to this being complied with more often. And I suspect, and I know it's all slightly vague, I suspect the answer is that we can't ignore this, and that in future the courts will consider it. And nobody has any more guidance than that at the moment. But my view is that the courts will be looking at this more often. And I also think that the likelihood is that when it's ordered, if somebody just doesn't attend, sanctions will be imposed. As to how you deal with sanctions when somebody is alleged to have failed to engage, I agree with everything that has been said previously, and I suspect, as these sanctions would only be imposed when the case is finished and the costs are being considered, then there may well be inroads into the sanctity of the without prejudice nature of the discussion.
Thanks, Brian. Dominic, you've sat as a recorder for many years, so you will understand the position of the bench. What is your answer to this question? Are we going to see more at CCMCs on this subject?
Yes, I think to take up a point that Brian said, I think I would be surprised if there were not behind this judgment some directive from on high. Now, whether that is in a soft and slow way by terms of judicial training or judicial renewal of civil training, the point is made that now we push for ADR right through to the other extreme, which is a directive from the Master of the Rolls that all masters and district judges must, the first time the case is before them, make proper inquiries as to what has been done re-ADR and or what is proposed by ADR. Even to the extent of, at the first CCMC, both parties must complete a form. What have you done about ADR and what are your proposals? I can see it becoming quite prescriptive that the ADR hurdle, as it were, is put forward. I don't think that's necessarily going to be a sea change in people's behaviour. I think all the personal injury and clinical negligence solicitors sitting in, or other advisors, or those stakeholders, to use the phrase, sitting on this, will, I'm sure, be very used to the idea that they're always thinking of ADR. I just think there's going to be an impetus where you're going to have a strategy in advance and be ready to anticipate. I think that's the sea change. As for sanctions, if the Civil Justice Council's proposed general protocol comes in other words, you have to do ADR before you can issue. Well, the straightforward sanction is a stay of the proceedings as issued until. Anything more complex than that as a sanction is very hard to think of at such an early stage. I think we may fall back to a sort of Halsey situation where it all comes out in the wash. In other words, once the case has been decided, then the judge will look at the behaviours or the compliance and say, well, I'm going to punish it in costs. The only problem with that, of course, is that for the party who thinks that the other party is not cooperative, they have to wait a long time for the justice of that to be reflected, and it's never certain that it will be.
Thank you. Francis, from a practical aspect, I know that you've had some involvement in the Grenfell litigation. Has ADR figured there in the case management aspects?
Well, yes, it has. I mean, the Grenfell case is a very complex piece of litigation, as you can imagine, involving lots of different groups. There are claimants who are bereaved or survivors, and they're in different cohorts represented by different firms of solicitors. There's the emergency responders who are divided into 3 groups, separately represented, and there's over 20 defendants, all tooled up with their representatives as well. So it's been a very difficult case to manage from a court's perspective. And Master Fontaine was doing it until she retired, and Master Cook has just taken over. And it was Master Fontaine who stayed the case to allow the mediation process to continue. And it was largely by consent, but not entirely. So there was a group who didn't want it to be stayed, wanted justice a little bit quicker. But she was very clear that you could actually, the court was empowered to order mediation and was empowered to stay the action while that happened. So if I may, I'll just read out a little bit of what she said in one of the judgments from one of the case management conferences. And she said, further, the clear direction of travel in recent authorities, and bear in mind this is pre-Churchill, sometime pre-Churchill, on the court's power to influence parties' participation in ADR is towards mandatory mediation. But it's declared lawful by the Civil Justice Council in its July 21 report. And then she goes through all the different cases, goes through the white book, and concludes by saying the court has the jurisdiction to order the stay of proceedings specifically until parties make adequate efforts to engage in ADR. And then she continues about why in this particular case she thought it was a good idea. Now, what's happened more recently in that, I can tell you, is that some of the mediation has been successful, and various groups as a consequence have fallen away. And so Master Cook in a more recent hearing has just decided to continue the stay to allow that mediation to continue. And so it's clear that the senior master was very clear that she and then he had the power to order a stay for the parties to continue to mediate. And really it was whether they wanted to or not, although, as I say, the vast majority of the parties were content for that to happen, particularly as it's proving to be successful. Then obviously there's a greater degree of enthusiasm from all the parties to have it continue. But it's very, very difficult, and you can imagine how complicated it must be to mediate with all those different defendants, all, I'm quite sure, saying different things, and all the claimants saying different things as well, and trying to manage those groups. So it is a really challenging thing for the court, but this is the way they thought was the best way of dealing with it.
Thank you. We've got a couple of more questions about stays, but before I get to that, there's one about limitation, and the questioner says this, that clients often in clinical negligence cases don't instruct solicitors until a relatively advanced point in the limitation period. There is often insufficient time to complete the evidence and value the claim before proceedings are issued. How is the tension between limitation and the compulsion to engage in ADR best resolved? Dominic.
I think I can help on this. Well, it's a very interesting and appropriate question, if I may say. Interestingly, the CJC proposed protocol expressly says limitation will continue to run. So the problem has been identified by the questioner as a very real one. Obviously, I can't give advice in any specific case. I'm speaking generally. But in general terms, I think the answer in that circumstance to say is to address that tension by going straight to your proposed defendant and say, this is a situation we have recently been instructed, we need to make inquiries and so on. Will you permit a delay, an extension's limitation period? And I'm giving nothing away. Of course, I do both sides of clinical negligence, claimant and defendant, giving nothing away to say that request will be more favorably received if it is specific. Obviously, you can't waive privilege, you can't say who you're going to, you can't say what your fears are, what things you need to address, but you would say, well, we need a period of till this particular date when we think we will have things in order. And a defendant, I would be surprised if defendants objected to that, if it was reasonable, wasn't too long and so on. But if they don't, then you issue your proceedings along with a supporting statement saying we're issuing proceedings now without ADR having been explored for the following reasons. And the defendant who's been difficult will possibly have a cost sanction. So I think very wise question, very perceptive question. The answer is try to get some cooperation going with your opposite number, and to accommodate a reasonable approach to ADR before you have to issue.
Thank you. I would add that I've fairly often mediated in cases where a stay has been agreed on limitation, and the mediation is when we get the request in that for mediation, it's can we have a mediation before such and such a date, because there is a stay until that time. So it is not uncommon.
Sorry to add, but my experience is I act for a lot of defendants who, for specific reasons in specific circumstances, are more than happy to agree a postponement of limitation period for a defined period. Who wants to incur the court issue fee if it can be avoided? £10,000.
Thank you.
Can I chip in on that? So as a person who in one part of my life was stepping away from being a DDJ and a mediator, was responsible for negligence claims. I think this is a very real question. I heartily agree with what everybody says, but I think if in any doubt, my suggestion is issue and apply for a stay, and then it's in the court's hands. And if a court are encouraging ADR, then I appreciate that the defendants might not like the additional cost of issue, but it covers you, so you are pretty well bomb-proof. Whereas if you agree, particularly if you've got a number of cases, if you agree stays in more than a few cases, then you are putting your chin out, and things may go wrong.
Thank you. Let's move back to the question of stays. Then we've got a tricky cost one coming up. This is the Bristol experience. Two questions here. First, I've had an order allocating to multi-track and a stay to enable the parties to mediate. No listing for a CCMC yet, Bristol County Court. And coupled with that, another one, do you think courts outside of Bristol District Registry may take a similar approach as supported by His Honour Judge Relton, by adding a stay between issue and CCMC to allow parties to engage with litigation? Now, I had occasion to visit the Southwest just a few months ago, and I heard His Honour Judge Relton speak, and he has an almost blanket approach of issuing a stay. So this is not, he didn't wait for Churchill, he was issuing a stay already. So the question is, are we going to see that that approach more often outside Bristol? I'm interested if anyone has any experience of those stays. The judge was keeping count, by the way, and I think there was a significant number of cases were not returning, other than to say settlement had been reached.
Speaking for myself, I think that sort of approach is going to become the norm. I do expect from on high at some stage a directive or guidance that at the CMC, before the CMC, there ought to have been an addressing of the question of ADR. How that's achieved, it sounds like Judge Railton's sort of got that going already, and quite forward-looking. And again, it emphasises my point that we need just to get our head in the space that this is what's going to happen, is that we're going to be expected to have addressed the question of ADR quite early, and not necessarily right at the start. But it's I think that's the way things are going. I don't know if Brian has a different view.
I think it may well be. Again, I'm not important enough to know. I've not heard the gentleman speak, but I think you may be right that this is a direction of travel. My own view is that, from a personal perspective, I'd rather know a bit more about the case to decide whether I felt it was appropriate for mediation, rather than do a blanket stay for that purpose. But I agree with you that we're probably heading in that direction.
Can I just say, I'm sure I'm not alone in experiencing with certain courts, there is such a massive delay between filing direction questionnaires and getting a date for a CCMC that you might as well be engaging in mediation. So it will be helpful in those cases if they got an order, so at least you could be doing something.
Thank you, Francis. Let's get on to the tricky cost one now. I know there's some cost lawyers have registered, so we may get some answers to this question from the audience. I don't know the answer to it. Thoughts of how current fast track and intermediate track fixed cost tables will impact the court's approach to or expectations of ADR. So thoughts on how current fast track and intermediate track fixed cost tables will impact the court's approach to or expectations of ADR. Anyone like to comment on that? I'll say what you think about it. The intermediate track does have provision for ADR and preparation for ADR, so that is in the thinking of the cost table already. But my suspicion that so far not a great deal of thought has been given to that very practical, pragmatic question. But any observations from the panel, or indeed from the audience?
I doubt the courts have thought about that at all, really. And I think the only thing they've thought about, as you say, there is provision in the intermediate table for ADR. So that's fine. As far as fast track is concerned, I'm sure it hasn't crossed their minds. And I think it'll only be for the parties to make a decision about whether it's helpful and useful to them to get the matter dealt with quickly through ADR.
I agree with that. The only thing I would comment was the difference between, in terms of, just deal with sanctions first and then that specific question later. Up until now, the courts, as I said, previously been reluctant to impose sanction for failure to comply with the protocol or engage in ADR, because it is the spirit of the rules. But if the courts are ordering ADR and parties are not complying, then that's a breach of a court order. And there the courts will be much more willing to impose sanctions. So I think they will. The answer in that regime is how are they going to? Because at the moment, as I understand it, and I'm no great expert in this at the moment, but because I haven't really come in yet, but Part 36 is very limited. There's no provision apart from conduct to go to outside of fixed costs into indemnity costs. But I suspect that's how it's going to work. That if the courts say there's been breach of a court order, then they will have to step outside of the fixed cost regime to impose a cost sanction.
Thank you. Well, I've had a number of discussions with people about Churchill, and I get the impression there are a number of things which are up in the air and still being thought about, and I think that's one of them. Another question that I've heard put it is this. Well, my approach to ADR is we'll have a JSM after the exchange of evidence, after joint experts have met and so forth, and that will be our ADR. Will that suffice? So any thoughts on that, please? If the ADR is after close of pleadings and evidence?
Undoubtedly it will survive. The other side of the coin is if you have experienced lawyers who say to the court at the CMC or at some other stage, we do have ADR in mind, but we think it will be most effective at this stage, filling details in this particular case or generally in this sort of case. I would be very surprised if the court said anything against that. I don't see any. I think the court sees its role here as one of strong encouragement, but not necessarily the big stick. I think the big stick is being waved of this power to order mediation. But I think the real hope is that it just becomes part of the culture, that some form of ADR occurs in every single civil case, right the way down to an informal meeting between two parties that they just decide to have. I think right up to the 5-party mediation or whatever. So I think no question. But if you have a plan to have ADR, but it's further down the track for good reason, I do not expect the court to stand in the way of that.
Thank you, Dominic. Well, let's go over to our poll questions, and I would like to put some questions to you for you to complete on the poll. And our first question is coming up now. This question that you'll see is addressed to personal injury claims. And voting is going on. We'll leave it a little while yet. The next question I can tell you is a similar question on clinical negligence. And the voting has settled down, and the response is that 17% of people think that the impact will be minimal, 67% think it will be moderate, and 15% think significant. So that's question one. Let's go to question two. Yes, the results are on screen there. So I get to poll question 2. Same question, but clinical negligence, where of course mediation has been present in the culture for quite some time now. Voting still occurring. And that has settled down, so then poll and share results. And you can see a not dissimilar set of results there, 62% moderate. And I think that demonstrates that there is a quite culturally ADR is part of the fabric already. Let's come to my 3rd out of 4 questions. We've discussed this issue. Let's see your views on it. And people are being more thoughtful about this. The voting is slower. Still 1 or 2 votes coming in. I'm going to end the poll now. So 18%, but a total of 81% think that satellite litigation is going to be moderate or significant. Interesting on that. And finally, that this is really for a question for trust mediation, because we're interested to know to what extent personal injury and clinical negligence lawyers think that training is useful at this juncture, bearing in mind all that's been said today. And again, that's settled down, so as you'll see, 22% as before, 65% slight increase in training needs, and 13% significant. That's interesting, bearing in mind that our cohort today is of people who have an interest in mediation. I'd be interested to carry that poll out with people who would have no interest in attending this webinar today. I think the answer might be somewhat different. Well, thank you for sharing your views in that way. And just to say, I'm not turning this into an advert or anything, but Trust Mediation does have training services, which we're very interested to make available. We also are introducing a new concept, which we've been developing for some time, and that is to have an ADR liaison person or a DR coordinator. We can't quite decide on the name yet, at each firm to operate as the go-to person in that firm of solicitors. And we would provide resources to that person, so that in terms of questions from colleagues and clients, they have ADR resources directly from us, and also a hotline to a mediator to ask about cases. So if you're interested in that, please let us know. I will, as I have promised, circulate details of the cases and various references made, so that they're available to you, and that will be available by the end of the week. And the recording of this webinar will also be available. Thank you very much indeed for your interest and your questions. We will certainly be looking at everything that's been said today. And there was a final question come in. So I see on my screen another question. It was simply a thank you for the session. So I join that member of the audience in thanking all of the panel for their hard work today, and thank you for everyone for logging in and supporting us, as you have done on this webinar series throughout the year. Many thanks, and I say good afternoon to you. Goodbye.